I'm still struggling to get my answer on whether or not the fact that Kelly Khumalo is a kingpin in the matter of SENZO MEYIWA was part of the narrative that the team of prosecutors, actually let me not say the team of prosecutors, but the office of the DPP Pretoria had when they decided on this matter. I haven't received my answer. And I don't know what is the difficulty in saying, yeah, no, DPP Pretoria was of the view that Kelly was a kingpin in this case. However, she could not be charged because of this and this and this. That would have sounded better. But to simply decide not to answer my question, clouding it with a whole lot of lengthy explanation, I really don't think that assists the court. But nonetheless, I realize that there's an objection from my colleague.
As a court, please, my lord, and we don't want to belabor this point. The witness is clear that the discretion to charge lies with the Director of Public Prosecution. He presented a memo, and this is the decision was taken by the Director of Public Prosecutions. He cannot take it any further. He said, he cannot, as he put it, go into the minds of, the Office of the Director of Public Prosecutions. I think my learned friend will unfortunately have to live with that answer.
And unfortunately, I am not prepared to live with that answer. But I do realize that it's a very difficult one. But nonetheless, let me proceed. You know, the reason why I am asking this, it's because in terms of the law, when a person gets indicted at the High Court, in terms of Section 144 of the Criminal Procedure Act, the state must inform the court the facts upon which they are basing their allegations against those that they've indicted before court. That is law, which is the reason why I am asking you that question. Do you understand?
My lord, I understand. However, and I go back again, my part as an investigating officer, and exactly that, my lord, was done in the matter. It's a question of separation of powers, and I've explained this, my lord. The docket was taken to the DPP, as is normally done, for a decision. A decision was taken. Now, for me, my lord, it's not a difficulty, but I can't speak on behalf of the NPA. It's separated, my lord. I did my part. I produced the evidence that we had insofar as this accused and what pointed to Ms. Kelly Khumalo. It's a normal, that's how it's done, my lord. You present it to the NPA, then they will communicate their decision to you as they've done in this instance. Now, I'm not sure, my lord, how do I then speak on behalf of them? I think the NPA in this situation, my lord, are better vested with the knowledge of giving Mr. Advocate MNISI the answers that he seek, because I can't speak on their behalf, my lord. Same with the section or the law that Advocate MNISI referred me to. I'm not sure, my lord, how best can I assist him there. I mean, that lies between him and I think the court and with greatest respect, the Advocate Baloyi. Because what do I say, my lord? That's not my terrain as well. Yes, my lord.
Now, you're mentioning that you investigated the docket, you gathered all the evidence and presented it to the state. Now, was it part of your, before I get to there, and then after submitting that document, then the state went on to make a decision to charge the 5 accused persons that are before court here, and they gave you instructions to go and issue out warrants of arrest against them, not so?
My lord, the first part is correct. A decision was taken and then an indictment was sent to me. I'm not sure if there was instructions to say go and get warrant of arrest. I mean, as I've said before, my lord, J50s are a way of bringing the accused persons before court because the decision was already taken that, they're indicted for these charges. I then took that route, my lord, of applying for J50s as per the affidavit that I disposed. And then that was solely granted, my lord. And then the accused were brought before court.
Thank you, Brigadier. Further that Part of the instructions in that indictment was that they should be arraigned for trial in the High Court.
I suppose, my lord, I'm just not sure word for word now because I'll have to go through to the indictment, my lord. But I suppose if Advocate MNISI saw it recently, I will not dispute that.
Yes, that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Khumalo is also complicit in the murder of SENZO MEYIWA?
So MNISI asked the question a good 10 minutes later, because remember, I'm removing the parts where the interpreter speaks, okay? So it's a good 10 minutes later where Baloyi objects. Gininda can answer that question. He's not the DPP. And Gininda's like, listen, I'm going to ride that horse. And he goes on and on and on. I can't help MNISI. He must go and ask the NPA. I don't work for them. I took the docket there. They didn't give me the answer. So for the answer that you really, really want, you got to talk to the NPA. I cannot help you. And with regards to the law, because MNISI had quoted in terms of section 144 of the Criminal Procedure Act, Mr. I am studying my LLBs says, I don't know what you want me to do with that information because, you know, that's not part of my terrain. Today, he walks away from any legal knowledge. That's not part of my terrain. I don't know if the court can help you there. It's not my business, okay? It's not my business. And MNISI goes, you know what? It's Friday. I have got time, okay? I've got time. Listens to all that. And then he proceeds to ask the same question again. Like, MNISI is a problem child, okay? MNISI is a problem child. I never want to ever be in an argument with him because you're never going to win, okay? That's the bottom line. He's patient. He's going to drag you, and he will drag you with a smile on his face. I think that's the worst part about it. He drags you with a smile on his face. He doesn't lose his temper. He doesn't get upset. But one thing he's going to do, he's going to use facts and the law to nail you. And the coffin that is put Gininda in is beyond 24 feet under. And he says, it's okay, no problem. So when you arrested the 5 accused over here, the ones that are here in court, obviously you followed the procedures. And I see that. Okay, great. Was Kelly Khumalo also part of that docket? Did the NPA, did the office of the DPP in that document, did they know that Kelly Khumalo is complicit in the murder of SENZO MEYIWA? I mean, that was just brilliant, okay? So satisfying. But let's continue on because I want to hear the answer.
My lord, yes, I presented all the evidence as it is. And as I indicated, part of my recommendation or request was that she should be charged. But then there were further instructions insofar as she is concerned at that stage, my lord.
And based on your investigation, you were satisfied that there were reasonable grounds to believe that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the murder of the deceased.
Yes, I was, my lord.
Now, this is what the state told this court in terms of Section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. And I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial facts which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
As it is the court, my lord, I think that is, it's a misdirection, it's a misrepresentation of fact. It can't be had to be said that and information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case in my line of cross-examination? I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case. Then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid. I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case. Definitely.
Yes, Mr.
Well, I don't know what daring and the guilt refers to.
Maybe
but
let's read section 104.
yes. But such obnoxious comment notwithstanding, my lord, we submit that this witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. And we don't want to repeat ourselves, my lord, but we submit that that line of cross-examination should be disallowed. Did the court say I must read out section
so that's it.
144?
People understand what we are about. Because we're quoting sections which maybe some people are not even aware what they say. I mean,
The heading to section 144 is charge in superior court to be laid in an indictment. It's a very long section. I'll read the whole of it. Subsection 1. Where an Attorney General, now the Director of Public Prosecutions, arraigns an accused for sentence or trial by a superior court, the charge shall be contained in a document called an indictment, which shall be framed in the name of the Attorney General. Subsection 2. The indictment shall, in addition to the charge against the accused, include the name and, where known and where applicable, the address and a description of the accused with regard to sex, nationality, and age. Subsection 3A. Where an Attorney General under Section 75, 1213B or 1222 Roman figure 1 arraigns an accused for a summary trial in a superior court, the indictment shall be accompanied by a summary of substantial facts of the case. That is what we are currently debating. A summary of substantial facts of the case that, in the opinion of the Attorney General, are necessary to inform the accused of the allegations against him, and that will not be prejudicial to the administration of justice or the security of the state, as well as a list of the names and addresses of the witnesses the Attorney General intends calling at the summary trial on behalf of the state, provided that, Roman figure 1, this provision shall not be construed that the state shall be bound by the content of the summary. This is the point that we've just made. Roman figure 2, the Attorney General may withhold the names and address of a witness if he is of the opinion that such witness may be tampered with or be intimidated, or that it will be in the interest of the security of the state that the name and address of such witness be withheld. Roman figure 3, the omission of the name or address of a witness from such list shall in no way affect the validity of the trial. In this matter, there were certain names that were omitted. Roman figure 3b, where the evidence for the state and the trial of the accused differs in a material respect from the summary referred to in paragraph A, the trial court may, at the request of the accused, and if it appears to the court that the accused might be prejudiced in his defense by reason of such difference, adjourn the trial for such period as the court may seem adequate. Subsection 4, Roman figure 1, an indictment together with a notice of trial referred to in the rules of court shall, unless an accused agrees to a shorter period, be served on an accused at least 10 days, Sundays and public holidays excluded, before the date appointed for the trial, Roman figure 1, in accordance with the procedure and manner laid down by the rules of court, by handing it to him personally, or if he cannot be found, by delivering it at his place of residence or place of employment or business, to a person apparently over the age of 16 years and apparently residing or employed there, or if he's been released on bail, by leaving it at the place determined under section 62 for the service of any document on him, or Roman figure 2, by the magistrate or regional magistrate committing him to the superior court by handing it to him. Then subsection 4b, a return of the mode of service by the person who served the indictment and the notice of trial, or if the said documents were served in court on the accused by a magistrate or regional magistrate, an endorsement to that effect on the record of the proceedings, may, upon the failure of the accused to attend the proceedings in a superior court, be handed in at the proceedings and shall be prima facie proof of the service. Then lastly, subsection 4c, the provisions of section 55, 1 and 2 shall mutatis mutandis apply with reference to a notice of trial served on an accused in terms of this section. So, my lord, this simply buttresses the point that was made by the state earlier on, that the DPP, in his opinion, has set out a summary of substantial facts. This witness can be of no assistance as far as that is concerned.
Let's hear you, Mr. Minister.
As it please the court, madam. May I respond?
Hello?
I'm saying, may I respond?
No, you must address me on the law. Because you
That
say...
is what I'm saying, madam.
Also, you're saying?
I'm saying, may I respond?
Yes.
Yes. I think my colleague is running away from telling the court about what you read being a prejudice.
What?
Prejudice to the accused. These accused persons, my lords, have been arraigned to this court to answer the allegations that are contained in the summary of the substantial fact. And there is nowhere in the summary of the substantial fact where Kelly Khumalo is mentioned as a kingpin. Instead, in the summary of the substantial fact, Kelly is mentioned as a victim. Now, all along, throughout the testimony of Brigadier Gininda, Kelly Khumalo is branded as the kingpin, the person who organized the killing of the deceased, which is the reason why I am asking if at the very inception, at the drawing, at the preparation of the summary of the substantial facts, the state was aware that Kelly was a kingpin, so that when it decided to draw this summary of substantial fact, that should have been a factor to be taken into account, so that when these accused persons come and answer on the allegations that are against them, they know that amongst others, we are before this court to answer allegations that we were in consort. We worked together with Kelly Khumalo to assassinate SENZO MEYIWA, and that is not there. They are now expected to answer on something that was initially not put to them at the beginning of the trial. Remember, my lord, when the charge is being put against this accused person, the summary of the substantial fact is also read into the record. That is part of the charge sheet. There is nowhere where they were called upon to come and answer that they worked together with Kelly Khumalo. That is the reason why I am basically asking, and I'm not trying to indict any person. I'm getting somewhere with this line of cross-examination as to whether or not at the preparation of this indictment was the state aware that Kelly Khumalo, without Kelly Khumalo, would not have been here basically, as per the testimony of Brigadier Gininda. We would not have been here because accused persons would not have had anyone to come. According to the allegations of Brigadier Gininda, these accused persons would not have had anyone to entice them to go and kill SENZO MEYIWA. But that is not contained in the summary of substantial fact. It doesn't matter, my lord, whether a person is charged or not charged, but the summary of substantial fact must contain the information that is contained in the case docket, so that when the accused persons are confronted with that allegation, they are able to respond accordingly. And that has not happened in this case, which is the reason why I am compelled to find out, because now they are expected in the middle of the trial to answer to something that has not been there at the inception of the trial. There's nothing wrong in me finding out whether or not at the time at which the decision was made, the state was already aware that
But you're arguing something different.
No, okay, my lord, let me hear. When the court says it's different, in what way, my lord?
No, let's play your question first, because you're into the merits, etc.
No,
What
I'm
was the-
responding
wait,
to
wait,
the
wait.
I'm responding to the state, my lord.
What were you responding about the irrelevance of this witness being cross-examined?
What is it that Baloyi has to hide? What does Baloyi have to hide? Because he is not interested in MNISI, who was about to read us 12 pages. 12 pages of the summary of substantial facts. And listen, I was ready to listen to it. Okay, no, 12 paragraphs. I was ready to listen. Okay, because I wanted to hear it. Now I have to go back in time. Excuse me. I have to go back in time and find when Baloyi read that thing, because, you know, MNISI ended up not reading it. MNISI should have read it. MNISI should have read it. But anyway, Baloyi objects, and his objection, of course, makes absolute no sense. And then MNISI says, unless, of course, the guilty are afraid. And I stand with MNISI, okay? If you stand with MNISI with that comment, type it in the comment section, okay? The guilty are afraid. Because MNISI didn't lie. I don't think he was trying to pick a fight. He was just basically trying to explain that, listen, I don't understand what the state's issue is with this. I've been asking this question. I'm not getting a straight answer. And it's something I need to know. I need to know, okay, if the kingpin, if the NPA knew about the kingpin, and if they knew about the kingpin, why is the kingpin not seated here? Because the 5 accused are here. They are here, and they are here because it's all Kelly Khumalo's fault. She's the one who enticed them. That is Gininda's case, and he's been saying it over and over and over again. And this is MNISI's way of saying payback. You should have. I told you a long time ago, stop repeating information. But since you insist, I'm going to put it on the record for you. I'm now going to put it on the record. Excuse me. I'm now going to put it on the record. And, you know, when I put it on the record, I'm going to put it so well. You're going to regret ever mentioning this to me. And now MNISI makes a good point. The 5 accused are here because they were enticed by Kelly Khumalo to take out SENZO MEYIWA. Without Kelly Khumalo, there would be no 5 accused. So where the hell is Kelly Khumalo? Okay, accused number 0. Can she attend the dock, please? But Baloyi is running, okay? Is running. Ujiga ngazo zombili, okay? He is running like is running. He doesn't want to be involved, okay? He doesn't want that answer known that they knew. He knew. He knew. I think that's a TikTok sound. I don't know why it's playing in my mind, but okay. I don't know what's happening to my voice as well, but Baloyi knew, okay? Baloyi knew. Baloyi knew. And now the guilty are afraid. Allegedly. I stand with MNISI on this one. It makes absolute sense. Because otherwise, why is the kingpin not... The AKA case is in court. The kingpin is right there inside. No, the kingpin is not inside. But the kingpin also over there has been mentioned. Okay. Gininda, okay? Gininda. But, yeah, let me end it here because it's going to be too long. And then we'll continue. Okay, we'll continue part 3.